Welcome to In the Name of the Law with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, Kent Wood of Wood & Associates, PLLC, along with Mary Chartier and Takura Nyemphakusa from Chartier Nyemphakusa, PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people with real legal problems. Today's episode, we're going to talk about the criminal exoneration of Ken Nixon, who was wrongfully convicted, the friend of court process in family law cases, and how the new auto insurance law impacts motorcyclists. Stay tuned for another great episode.
In the name of personal injury law.
The recent changes to our auto insurance no-fault law impacts everyone in the state. But motorcyclists are a special group of people who are impacted differently by the no-fault law changes. Today we have Steve Sinus, a personal injury attorney at the Sinus Dramus Law Firm, here to explain how motorcyclists are impacted by the new no-fault law.
Thanks for having me.
So Steve, first, explain the special concerns that you have for motorcyclists with respect to the no-fault law.
So I've had the privilege to represent many motorcyclists throughout my career. They obviously love what they do in terms of being able to get out there and ride their bikes. Unfortunately, when bad things happen and they're in a crash, their injuries can be severe. There can often be liability disputes in terms of arguing who's at fault. There's also special considerations about whether motorcyclists, can claim benefits under the no-fault insurance system. So they're just a unique group of people, and they need to understand their rights, and those rights have been affected by these reforms, so we're here to talk about that today.
So before we get to that, can you explain how it worked for motorcyclists under the original no-fault law?
Yeah, so just to get to a basic point, under the original law, if a motorcyclist was just riding down the street and there was no other motor vehicle involved in the crash, say the motorcyclist just went off the road and hit a tree, if there's no involvement of a motor vehicle in how that motorcycle crashes, there's no-fault benefits. But if there is, the motorcyclist can claim no-fault benefits through the no-fault insurance system. And under the original law, everybody was entitled to lifetime coverage. So if a motorcyclist could pass this test, that meant the motorcyclist would have access to the no-fault insurance system and have their care and treatment covered for life. And the other rule that was under the original law is that as a way of dealing with who pays for those benefits, the law had it so that the system covered motorcyclists by having them recover their no-fault benefits from the motor vehicle's policy involved. So if I was on my motorcycle, and I was riding on the street and you came and somehow were involved with the crash, I would claim no-fault benefits under your policy. But it was all lifetime coverage, so it didn't really matter whose policy we were recovering from. And that's how it worked under the original law.
Okay, so how did the 2019 reforms change the reality for motorcyclists?
The reality is changed because now fundamentally people don't have to buy lifetime no-fault medical expense coverage. People can buy $50,000 of medical expense coverage if they're on Medicaid, or $250,000 of coverage, or $500,000 of coverage. Nobody has to buy lifetime anymore. And so with that system being in place, when a motorcyclist is in a crash, going back to my hypothetical, if I'm on my motorcycle and you hit me, but you chose to buy $250,000 of medical expense coverage, I would be subject to your policy and subject to your cap, even if I bought lifetime no-fault medical expense coverage for my own vehicles at home. So they changed the insurance buying options for motorcyclists, but they didn't change that rule that you draw from the vehicle involved. And now motorcyclists are at the mercy of the insurance buying decisions of the motor vehicles involved in the crashes that hurt them.
Which is exactly the opposite for anybody driving a car.
Right. People driving a car, and the whole reforms were based on people having choice, people being able to choose their own fate. But motorcyclists can never choose their own fate under the reforms.
So are there any other sources of recovery for a motorcyclist who is in an accident?
Yes. They can pursue an auto negligence claim. So let's go back to my hypothetical. I'm on my motorcycle driving down the street and you hit me and it's your fault. You have $250,000 of no-fault medical expense coverage. I can pursue that from your no-fault insurance coverage. And then I can sue you for my uncovered medical expenses. But there are limitations I'm going to have to deal with. The one limitation is the extent of liability insurance coverage you bought on your own vehicle. So you have $250,000 of no-fault coverage, maybe you have $250,000 of liability coverage. If I'm paralyzed as a motorcyclist or severely brain injured, that's only $500,000 that I can recover in total for my medical care, whereas under the old system, I get lifetime. The other issue with liability cases is that you're dealing with liability disputes, you're dealing with arguments about fault, and all that can be a reduction on how much I can recover from you. Let's say a jury were to determine that you were 75% at fault, but I was 25% at fault. It would reduce my medical expense claim against you by my own fault. So the tort claim is not a perfect source of recovery for injured people.
Are there any other limitations on the motorcycle driver getting money compensation from the at-fault driver?
Yeah, one other limitation that is a practical reality for the motorcyclist is that if their health insurance has to pay for the medical expenses, the health insurance can come in and claim a lien against the amount recovered from the at-fault driver. So the motorcyclist thinks they're going to recover a certain amount of money. Their health insurance said, well, we paid $200,000 of your medical expenses and we want that money back.
So even if you have outstanding medical expenses, the health insurance provider can take the first part of the award or all of it?
There can be a big argument about how much money they can take. And so that's a huge concern when motorcyclists are pursuing auto tort cases. There's a big difference in terms of whether the lien is through a state-funded source of insurance, such as Medicaid or Medicare. If people have private insurance through Blue Cross, that can lead to a different outcome. People have ERISA health insurance plans, which are self-funded insurance plans. So when a motorcyclist is in an auto tort case and they're pursuing a recovery for pain, suffering, and medical expenses, and they have a lien, chances are their actual recovery that goes to them is going to be greatly reduced by those lien rights.
So this is really troubling. Are there any legislative efforts to fix some of these issues that came out of the 2019 reforms?
Yeah, going back to what we were talking about before, I mean, the reforms were passed in the name of choice, right? People being able to choose their own fate. And so certain legislators have realized that now motorcyclists cannot choose their own fate. They're at the mercy of other people's decisions. And so there have been a couple bills introduced to fix this problem. Unfortunately, those bills have not gone anywhere in terms of a vote. It seems that the legislature overall is trying to say that these reforms are good enough for now and not trying to make changes. But I really think that the motorcyclist situation is a real example of unfair outcomes and unintended outcomes of this system. So hopefully they'll do something, but right now nothing's happening.
So give us your top recommendations, your ultimate insurance buying recommendations for motorcyclists who are watching this episode. How can you help them decide what insurance to buy?
All right, so unfortunately, your decision to buy no-fault insurance coverage isn't really going to help you all that much if there's this other vehicle involved that has no-fault insurance coverage. But you do protect yourself overall by buying lifetime no-fault medical expense coverage. So that might cost more, but I recommend everybody continue to buy that. You're also going to want to make sure that on your motorcycle, you have liability insurance coverage and that you have a significant amount of that, because people now can be held liable for each other's medical expense coverage. So you want to make sure you have liability insurance coverage in the event you were to make a mistake and someone were to bring a claim against you. And then there's also something known as uninsured or underinsured motorist coverage, which is coverage that applies when you're hit by somebody who doesn't have enough insurance, which is underinsured, or any insurance at all, which would be uninsured. And you want to buy that for yourself, and you want to make sure that that would apply in a crash involving your motorcycle. Because sometimes you can buy that policy with your auto insurance company and there isn't such coverage that applies to motorcycles. So you want to make sure it applies to your motorcycle and make sure that you buy as much as you can. It's a much more complicated system for motorcyclists. There's a lot to think through. If you follow those recommendations, you'll be fully protected, but or as close as to be as fully protected as you can, but it's still going to be more costly for you.
Okay,
Yeah.
right. Well, thank you for your advice, Steve.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm. In the Name of Criminal Defense.
Today we have criminal defense litigators Mary Chartier and Takura Nyampakutsa of the law firm Chartier Nyampakutsa, and a special guest, Ken Nixon. Ken was wrongfully convicted and imprisoned for 16 years. Welcome, everyone, to the show.
Thank you, Lisa.
Thank you,
So,
Lisa.
Ken, can you tell us what happened that resulted in you being wrongfully convicted?
In 2005, I was arrested for 2 counts of murder, 4 counts of attempted murder, and 1 count of arson. In the months leading up to the crime, my girlfriend at the time was having an affair with a very close friend of mine. For obvious reasons, it became a very contentious relationship. We got physical between he and I, a lot of stupid behavior, I guess you can say, between he and I. There was some violence exchanged. About a month or 2 prior to the crime, he and I finally came to the conclusion that we should just stay away from each other. You know, it was
But
best.
Ken, can I ask you, how old were you at this point?
I was 19 years old.
Okay, got it. Thank you.
He and I came to the conclusion that it was best that we just stayed away from each other. We weren't actually trying to hurt each other. It was more so scare tactics, you know, just childish scare tactics that we were being growner than we thought we were at the time. About 2 months after he and I made this agreement to stay away from each other, his girlfriend at the time that he was living with, someone set the house on fire. She had 5 children in the house. 2 children perished as a result of the fire. My name came up in the investigation because of our prior history. And once my name came up, I was the only suspect that they decided to investigate. The police got tunnel vision. They ignored all other evidence of any other suspects, and I was arrested within hours of the crime being committed. After I was arrested, I had no idea what I was being arrested for. I had no idea that the crime had even taken place. I didn't even know that any of this had happened at all. The detectives told me, you know, what had happened the night before. After being arrested, I later found out that the house fire was set by way of a Molotov cocktail. I was a 19-year-old kid from the inner city of Detroit. I didn't even know what a Molotov cocktail was. I had never even heard the term before. Prior to one of the first meetings I had with my attorney at the time, and he's going through the paperwork and explaining to me, you know, what the inner workings of the crime and how everything happened. After he finished, I asked him, you know, what was a Molotov cocktail? And he spent probably the next 45 to 50 minutes trying to get me to understand what a Molotov cocktail was. I still didn't get it, still didn't understand. However, I was taken to trial and convicted of a crime that I didn't even understand how to commit. I was sentenced to 2 life sentences plus 40 to 60 years. It took me almost 16 years to regain my freedom. After that, I was exonerated on February 18th, 2021.
Ken, when you were leading up to trial, did you think that you're an innocent man, there's no way you're going to be convicted? Or did the reality that sometimes, and unfortunately, a lot of times, innocent people do get convicted in this country? I mean, what was your mindset?
I was taught to believe that the system works the way that it was supposed to. So I thought and expected that logic would play itself out in the courtroom. Nothing was making sense to me. I had never been inside of a courtroom beyond traffic tickets. Nobody in my family had ever been in any serious trouble. So none of us knew exactly what to do, how to do it, where to go for information. We knew nothing. I expected the system to work. You know, I expected that my innocence would be proven. You know, even I think leading up to trial, my attorney at the time, from the very beginning, he wasn't convinced. But as the proceedings continued, he became more and more convinced that I was telling him the truth. Everything that I told him leading up to trial checked out. So he had no reason to doubt me. As we got closer and closer to trial, his confidence level in my innocence began to increase. And the morning of trial, I remember him coming to me in the bullpen and saying, I believe you, and I don't have a choice but to believe you because everything I'd said checked out. So as a kid, I couldn't fathom the thought of going to prison for something that I didn't do. And what was worse was that I was staring down the barrel of a life sentence for something that I didn't do. This isn't a gun case. This isn't, a 2 years or, a 6-month case. This was something that literally could cause me to die in prison. I just couldn't understand it.
What was your reaction when the verdict was read?
I was crushed. I don't remember anything probably for a few hours after hearing them say guilty. Like nothing mattered at that moment. Everything was spinning. Nothing made sense at that point.
Wow. So what evidence was found that ultimately led to your release earlier this year?
We eventually found memorandums through the Freedom of Information process. There was the first document that we discovered there's a memorandum that was written from one of the homicide detectives to his supervisor. It was written 3 days after I was arrested. And the exact wording of the memo says, "It's obvious our star witness is being coached by family members." That's in his writing days after I was arrested.
And that had never been disclosed to your lawyer?
No, none of my attorneys had ever seen that document before. In fact, I went a step beyond that after we got it, and I reached out to every one of my previous attorneys, and every one of my previous attorneys wrote me a letter saying they'd never seen that document before. The second memorandum that we eventually got our hands on was a memo from the prosecutor involved in the case. A month before trial started, his memo, also to the lead homicide detective, the opening sentence of his memo reads, "To be blunt, this case has serious problems. Our star witness has written 3 different statements to 3 different officers and then somehow found a way to incorporate all 3 statements. We need to find a way to corroborate this witness." That's his very first line of this memo.
And they still went
and he still went forward. It gets worse. That's the first page. His memo is actually a 3-page memo. On the second page of the memo, which we fought for almost 5 years to get the second page of this 3-page document. On the second page of it, there's a paragraph that indicates that the prosecutor knew that the victims in this fire, this was actually their second fire. There was a previous fire that was set 4 years prior at a different house in the exact same manner. And the suspect in that case was a previous boyfriend.
Wow. And all of this was withheld from your lawyers. This is remarkable. And unfortunately, because of TV, we have such limited time. But Ken is going to be a guest on our podcast, Constitutional Defenders, and he's going to tell you what is on the 3rd page of that memo and a whole bunch of other evidence that was withheld from his lawyers, how Ken earned his freedom, and Ken's work now as chairperson of the National Organization of Exonerees. Ken is not just out celebrating his release, he's working to get other men and women out as well. Ken, you are remarkable. You are just a remarkable man.
Thank you. Thank you.
Thank you, Ken. And please do listen to that podcast. It's going to be amazing.
Yes.
In the Name of Criminal Defense is brought to you by Chartier Niamfakusa PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Family Law.
I'm with Kent Wood, who is a family law attorney and the owner of Wood & Associates in Lansing, Michigan. Welcome back, Kent. And today we're going to talk about the friend of the court and the processes with the friend of the court. So first of all, Kent, what is the friend of the court?
Well, thank you, Lisa. The friend of the court, I tell people and clients, it's the friend of the court. It's not the friend of mom. It's not the friend of dad. It's a department basically in the court that's set up to help lighten the load for the court, because otherwise all these issues would be going to court. And they kind of focus on a few issues: child support, early, easy custody matters, and then enforcing of the parenting time order. That's kind of the main focus of what they do.
Okay. And what about, and they're involved both early in cases before there's ever a judgment, but they're also involved when parents start having disputes post-judgment. Years after the divorce, they might have disputes, and the friend of the court will get involved at that point too.
Oh, definitely. So they're involved, especially in Ingham County, like right away. Sometimes when you file a complaint for divorce in Ingham County, the friend of the court might send out mail before you even have a chance to get service and notify the other side that they're even being sued for divorce. But they're getting in to set up some temporary orders that'll be in place really regarding custody, parenting time, and child support from the kind of early stages of a divorce to when it's finalized, because a divorce, as we know, can't be finalized until 6 months after filing. So there's this whole time frame that has to be dealt with until that happens.
So there's a lot of different aspects to the friend of the court's involvement, and so I want you to help us understand that. I mean, there's terms that I've heard, such as friend of court investigation, or conciliation, or referee hearings. So let's start, I guess, with what is the investigation process?
Well, the friend of court investigation process and this, what is also called a friend of court information gathering conference, there's two types, but they're very similar in what they look like at first. They're informal meetings, right? Attorneys can come, they don't have to be there, but you're sitting down with somebody who's helping the court understand your situation, getting a general idea. You share the facts and circumstances. You share what you want. You share your income so they can calculate support. But they're just trying to get an idea of where things were at so they can have some kind of temporary. And then what happens after an investigation is there's kind of this recommendation, and then Ingham County gets sent right to what's called to a referee hearing. But if Ingham County calls it a conference, a facility information gathering conference, it happens like what most courts do is they have a recommendation. It kind of becomes a temporary order as to custody, parent time, and support, and then parties have a chance to object. They explain why they think they got it wrong, and then there's a referee hearing.
So I think there's a couple important points that if the parties are in an investigation or conciliation, the person at the friend of court they're dealing with is not an attorney, right? Oftentimes it's a non-attorney. It's not until they get to the referee hearing then you actually have to have an attorney. And that the conciliation, at least it used to be, and tell me if it's still true, the conciliator would often try to help the parties reach an agreement, like so they didn't have to go to court, right? So they could come up with an agreed order that they could live by.
Right. So it's about, a judge said this the other day in a hearing, so I'll use his number, but it's about 6% of all divorce custody matters that actually get to a trial in front of a judge. A big chunk of those, probably 60, 70% of those are handled probably at that Fig C level where they kind of get it and they're kind of close. And usually with the help of an attorney, even if they're close and you want to make some changes, you can adjust that a little bit. If it doesn't work out, that's where the referee hearing comes in. And that's usually an attorney. Usually the referee is actually an attorney who has hopefully some experience in family law. But they'll make a decision, and they'll make a decision under the rules of evidence. Meaning,
right, and there's recording, so there can be a transcript, so anybody who wasn't there, like if you get a new attorney, they're going to see everything that happened at that referee hearing. Whereas in the investigation or the conciliation meeting, there is no record at all.
Oh, absolutely not. The front of the court's process is pretty nice because it allows you to deal with some very sensitive, high issues and not have become public record. Mm-hmm. But once you get to the referee hearing, I tell everybody it's a mini trial. And in most courts, that's where you're having your biggest argument and chance to really make your statement as to what you want as it comes to the two big things, custody and parenting time. Mm-hmm. Whereas if you don't agree, there's a potential, the referee will make a decision and you'll be able to object to that. But that process is usually more streamlined because, again, the purpose of the friend of the court is to lighten the load of the court.
So let's talk about how long do these cases take in each of these phases? How long does it take for the investigator or the conciliator to do their job versus how long do referee hearings often take?
Okay. Well, the conciliation investigation actual meeting is maybe an hour to 2 hours long, tops. It's just kind of real top level. Can we work something out? Can we get there? They have a certain amount of time, about 14 days, to kind of create a recommendation and present it to everybody.
So pretty fast.
Right.
Okay.
So usually you're getting into that meeting usually within about a week and a half after filing. Mm-hmm. And then, however, somebody could object and go to a referee hearing. And now that's a scheduling issue then, right. Because just like the judge, you've got to get on their docket and they've got hundreds of cases going on. And some are now being scheduled into February, and here it's nearing the end of December, and people are going to wait 2 months before they can have a hearing.
And from what I've seen, referee hearings often take many days. You're putting on basically a whole trial in front of the referee, right? So it's not like often it's not a one day, it's multiple days over the course of some period of time.
Yeah, I've had a couple cases, and I'm in one now where we're going into day 3, but because of the scheduling thing, it's also month 5. So they've had this temporary order that nobody really likes, arguing over it. Now we're 5 months from that, and we still need another hearing date because it's not just wanting to make your point, it's the time of the court.
So what does the referee do after they hear all the evidence? The parties are represented by attorneys, and it's a recording. They see the exhibits. All of this is happening in the referee hearing. And then what does the referee do?
Well, the referee takes back, and sometimes we'll make some quick decisions to handle some things, but they'll step away, review everything again, and have a written opinion based on all the best interest factors and explain why they choose one way or the other in terms of custody or parent time and support.
Okay, and then if everybody's happy with that, that becomes the order of the court?
Yes, that will become the order of the court. At some point when you agree, that usually becomes the order of the court. And by not taking objection to something, it's treated as an agreement.
But if one of the parents doesn't like it, they can file an objection?
Well, they could file an objection and request a de novo hearing with the judge, which means it's kind of I'm going to do a bird's eye review of everything that happened. So you got to order the transcripts, which are expensive. And if you have multiple days of transcripts, you got to get all of those.
Get all the referee transcripts.
And they'll review, the judge will then review all of that and decide, is there enough justification to even move forward on the objection? And my experience in 15 years has been about 97% of the time, no. That's where I don't say they rubber stamp, but they've trained their staff well, so they're doing it the way they want it done.
So they make their decision based on reviewing the transcripts. Do the judges ever allow new evidence or more information to come in that wasn't available at the referee hearing?
No, it is a good point, Lisa. They never allow more evidence unless something's happened since the referee hearing. Okay. So if you want to bring in stuff that you knew about, like you wanted a witness that wasn't available, or you wanted some evidence that you knew was there but you just didn't get your copies in, the judge in court kind of says, sorry, this was your chance. That's why it's a mini trial. It's so important to be completely ready there because that's where the real fight places. And the only thing that they're going to take in is anything new happening after that date. And that's usually only about 21 days, so there's not much new that's usually happened.
Well, thank you. It does sound like the referee process does help lighten the load of the judges.
Yes, it does.
In the Name of Family Law is brought to you by Wood & Associates, PLLC.
Thank you for watching our episode of In the Name of the Law. And during the family law segment, we talked about the friend of court, which is a topic that I cover in my book, Kids Caught in the Middle: How Families Are Harmed When Judges Don't Follow the Law. See you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.